And with that, I'm going to proceed with the first topic that is related to stand career moments. So, Carolyn, the first question is, what was your first introduction to arbitration?
Well, that's, first let me say how pleased I am to be with you, how important young ICCA is in our segment of the profession. It's incredibly important. I'm delighted to hear you have 7,000 members. That is incredible. And at the University of Miami, in our international arbitration LLM, Young ICCA gives a scholarship. And every year I've had the Young ICCA scholar in my class, and they're always brilliant. So I always feel like I'm making a contribution by teaching directly to so many of the stars coming up in our profession. So with that background, my first introduction, I was fortunate indeed when I went to White & Case. I had some advocacy skills because I started at the Justice Department in the US in civil, and I was on the team in the AMCO Asia case. Then, you know, a young associate, I was working on the damages segment of the first proceeding in the AMCO Asia case. And that was only the second of the ever ICCA cases. You know, at that time, you knew everybody and you knew everything going on in every case, but just by knowing all the other lawyers involved. Then the lead lawyer on it was Charlie Brower, who left and went to the Iran-US Claims Tribunal. And by that time, I became a partner and I took over the case and led the case for the annulment proceeding. In the annulment proceeding, we won the first partial annulment ever at ICCA, and it was incredibly interesting in terms of the development of host state arbitration, because when we started the annulment proceeding, it was only us and Klockner. So we were really, you know, struggling to define what the meaning of Article 52 was, because, you know, you get the words of Article 52, you don't have all the other case law, you don't have all the other treatises. Our expert was Michael Reisman. So to work with him was an incredible pleasure, and really to develop the complete understanding and what we were able to advocate in that annulment proceeding. And it challenged applicable law, and at the end, you know, many very interesting subjects in today's world in international, you know, host state investor arbitration.
Well, thank you so much. And I believe those were very memorable events of your early practice and your career. And I would like to know if you could go back in time at the beginning of your career in arbitration, what would you have done differently?
Well, I don't know. I like what I did. I don't know.
Probably an advice that you could give to your younger self starting out as an international arbitration lawyer?
Well, I'm sure, you know, we always feel we can do better and we can do, you know, more substantively in terms of experience, etc. But I must say, I had a wealth of experience just with the various cases that I was working on, and had great people to work with. So, you know, it is very important to work with people who you respect and really learn from. And I felt that was the case where I was when I went to White & Case, and that's why I've been there since 1980.
Great, great. what was your greatest professional challenge and how did you overcome it?
Well, I must say I've had many. You know, in terms of cases, primarily, the Fraport v. Philippines case was a significant challenge in terms of putting the case together. I spent an incredible amount of time in Manila working with the Solicitor General's office, working with Toy Feliciano, who had in fact been a member of the ad hoc committee on AMCO Asia, which is where I met him. But he was the lead counsel in the Philippines together with the Solicitor General. So when I started working there, we built the facts in that case from the ground up. And that was challenging, interesting, fascinating, and I think at the end of the day, an incredible result. You know, another one, oh, go ahead.
Yes, and do you believe that from this incredible experience and working with these superstars in the field that were trying to construct the investment arbitration field, do you know that in this journey to the top, what would you say is the greatest lesson you have learned, perhaps from this case or from other experiences?
Well, for sure, you know, the significance of always performing with excellence. And at times you find it personally challenging because it requires an incredible amount of time. But that certainly means in terms of developing the evidence and the facts and testing it from all sides before you ever advocate it to a tribunal. And, you know, the law. I think being analytically strong and having a clear strategy that your client agrees with, and that's not an easy thing, is incredibly important. And it takes working closely with clients, managing expectations, because, you know, they don't believe they've done anything that was problematic, and yet they're sued for hundreds of millions. So you've got to work with them so that they understand what the issues are, what the risks are, and then develop a cohesive strategy that's realistic under the circumstances.
Great. Moving a little bit on ICCA, can you tell us how and why did you become involved in ICCA? And currently, I know that you are a member of the ICCA Inclusiveness Committee. So probably you can talk a little bit on how you plan to influence women and other minorities in arbitration through this new role.
Yes, well, thank you for asking. First of all, ICCA, so many of the lawyers and advocates and arbitrators that I respect were members of the board of ICCA. And when I started, you know, teaching at Miami with Jan Paulsen and Marieke Paulsen, he was at the time president of ICCA, and I said I really wanted to become involved more than I was, because in my view, really the stars of the international arbitration world were involved, and I thought it was something to be part of, and I did get involved, and I really enjoy the people tremendously, the issues tremendously, and I think where we've been able to move in certain areas of international arbitration is very important. Chief among them is the Inclusiveness Committee. It's working on a number of different areas. Mine, I have a task force on gender in international arbitration. And you know, we've done so much in that area with the pledge and everything else that's really been advocating more and more women being appointed to tribunals, etc. But I wanted to get all of the major institutions involved in the work of the task force to look at what had actually happened on the basis of the statistics and the facts in the past 10 years since the pledge started and Arbitral Women started, to look at, in fact, what has gone on. How many institutional appointments have there been? How many appointments by co-arbitrators? How many appointments by parties? And how do the percentages look? And we should have out, I of course think it's fantastic because I led it, but because it's so good, from all of the institutions' input and the fabulous input of one young lawyer, or many young lawyers that helped me with it. The task force report, it'll be on Kluwer. It's the task force, the interinstitutional task force on gender in international arbitration. And I think it'll be out next week. I looked at the final proofs last night and signed off, and I think it's going to be published like next week. The findings are incredible.
Yes, I was going to say the same, that the timing is just so convenient. And
yes.
well, pointing out that you find ICCA so useful for connecting with people, I would reiterate the invite to our colleagues and the audience to be members of Young ICCA. And you commented that in ICCA there were many professionals that you respected. And probably I would like to know if there was someone in particular from ICCA or abroad that inspired your career, or to inspire you in a certain manner that helped to trigger your passion for arbitration or any other similar purposes.
Yes, of course. Of course. There were so many. You know, one doesn't succeed in the world without having many mentors along the way. That is incredibly important. And I've had many. I've had many in my law firm who've helped me, but I've had many in the field. Certainly Justice Toy Feliciano, who was incredible, and I met him very early on in the first AMCO Asia annulment, but we were co-counsel in the Philippines cases, and we sat together in the ADF versus US. I was appointed by the US, he was president. Arbitration. I mean, we were together in many things, and he was an incredible mentor and influence, certainly. You know, Michael Reisman, having worked with him on several cases. Many lawyers, and Jan Paulsen, Albert Jan Vandenberg, so many have helped me in so many ways. And sometimes it's just interacting and listening to them. Sometimes when I sit on tribunals, I learn from people on the tribunals and from the advocates in terms of how they argue, how they approach issues. You always learn.
And you commented that some past experiences sitting as an arbitrator, and in these different roles that you have played as practitioner, arbitrator, professor at UM, have you felt a greater sense of accomplishment in any particular role? What has been your experience?
Oh, that's interesting. You know, I enjoy them all. I enjoy them all. They're all very different. You know, in terms of teaching, it's always exhilarating because of the students. And many times I teach my cases, you know, I teach in international investment arbitration, so I talk about my cases, and the energy comes from the students asking you, why didn't you do this? Why didn't you do that? Did you think about this? And it's really interesting to hear all of the different comments and approaches. And, you know, as an advocate, I love it. I love creativity. I love, you know, the analysis and the strategy. and, you know, finding ways to deal with difficult evidence, etc. So it's a constant intellectual challenge. And sitting as an arbitrator is also very interesting because you have the dynamic of the others on the tribunal and the lawyers who are presenting and how they're presenting, etc. I find it sometimes difficult not to make any suggestions, like, why don't you talk about this or that? But I tend to restrain myself.
Thank you so much. And now with that, I will pass the lead to Nico so he can continue with this interview.
Thank you very much, Orlando. And dear Carolyn, it's a privilege to interview you. And my section is about how to make a career in international arbitration and in a jurisdiction different from your home jurisdiction. So the first question I would like to ask you as partner at White & Case is, what do you think that are the most important skills a young practitioner must develop to stand out in arbitration? I think you just mentioned a few, to analyze the evidence and to be prepared, but I think we have 232 participants now that they are very keen to hear your experience and which are the particular skills that they should develop.
Well, you know, I think, and it almost seems trite to say, you know, do whatever you do with excellence. But if it means studying the evidence, studying the witnesses, you've got to do it. I still go, in my big cases, I do witness interviews. I do the examinations. I do some of the arguments, because you've got to know the evidence from the ground up. There's almost
do you have any strategy how to collect the evidence? For example, tables or charts, or somehow that you organize the evidence in a way that then you can find it most easily? Or
of course. And I thank God for computers every day. I mean, maybe I should be thanking someone else, but you know, you have to look at the evidence always in getting it, you know, into the database so that you've got the documentary evidence that you can run chronologies. I run issue files. I run witness files. I manipulate the evidence every way possible so that I can see what I've got, because you don't want to be making some argument about what happened that's flat wrong. And you've got to understand what your opponents are arguing. Sometimes they have good points that you've got to get around. So it takes a lot of work and big teams.
So there are no shortcuts.
Yeah, no shortcuts. Unfortunately, I wish I could tell you I had a silver bullet, but I don't. And then it's the integration of all of the evidentiary work with the legal analysis and the creativity, and especially in international arbitration. I mean, in commercial, maybe not quite as much, because you've got a contract or you've got an agreement or you've got something that provides a structure. You know, in investment arbitration, of course, you've got a BIT or you've got a multilateral and ECT. You've got something that'll set the parameters, but it's a little bit less rigid in terms of the constraints. And, you know, you also have the national law. You're always working with national lawyers from a given jurisdiction. So you're looking at all different legal systems, international, national, the arbitration rules. It's a very challenging and interesting.
That would be another question. And if you're a young practitioner and you want to invest in furthering your education, there are different options. Which of the following will you say is most valuable for a career in international arbitration, and why? And there is a multiple choice. If you want to tell us from 1 to 4 which is the most and the least important, will be great, but depends on you. You can choose. A, an LLM at home. B, an LLM abroad. C, a qualification as a lawyer, being admitted to the bar. Or D, a PhD. So LLM at home, LLM abroad, qualification as a lawyer, or a PhD.
Well, I think you've got to start with a qualification as a lawyer. I mean, you have to be, I think, in most systems, a lawyer, although I appreciate some systems have different qualifications. But I think an LLM in either international arbitration, international law, public international law is something that gives you, I think, a broader reach than just domestic is probably the best. A PhD is wonderful if you have the time and the inclination, of course.
Okay, excellent. That was very clear. Thank you. The following question is, what's your opinion on whether young practitioners should start working in small or big law firms? Which experience will be more valuable?
Well, that's a good question. And I guess I would say it depends who you're working with. If in a small firm, you may be working with just fabulous people. If you go to Three Crowns and you're working with Jan Paulsen and Luke Sabota, etc., you're working with great people. Why not? And, you're working directly a lot. If you're at a big firm, in a big group, if you're working with the International Arbitration Group and you're getting, decent responsibility, I'd say that's fabulous too. You've really got to look at exactly what you're going to be doing, who you're going to be doing it with. And there are a lot of different choices. But you could also start, as many have done, in your home government, and the department that does all the international arbitrations. You're going to be on your feet much faster. You're going to be arguing the cases, putting together the cases. And I must say, so much of what I learned came from my few years at the Ministry of Justice, at the Department of Justice, because I was putting together cases and trying cases. So that when I came to start working on arbitration, I knew how to do the basics.
That's very important. It really depends, case by case. There is not a straight answer.
No, there isn't. And, I think as well, serving as a secretary to a tribunal or even working at one of the institutions, you just get a vantage point and experience that is pretty incomparable.
Exactly. Thank you very much. Moving on to a different topic maybe. What is the biggest competitive advantage when entering the arbitration market in a jurisdiction different from that of your home jurisdiction? What do you think?
What do you mean by when you're competing for business, for a job, for?
Yeah, like when you enter into a new market that is not your home country, where it's not your home country, and you have some advantage and disadvantage, I think, because of the language maybe, or the law, or the question will be, what's the advantage when you move from one country, from your home country up to abroad, to another country, and what are the best things that you can get from that?
Well, people compete for things in many ways. Many times, if there is a particular, both education and language can set you apart. If you know that a particular firm does a huge amount of Russian arbitration, if you speak Russian and you've studied something about international arbitration, you may well be of great interest, even though that may not be your home country. If you're competing for business in other jurisdictions, obviously having some international arbitration experience and price. People compete like crazy on price. And that's how people get into new markets for themselves. And, then you really better perform. you really better perform.
Good. And do you have any advice on how to manage working under different legal systems and traditions like common law and civil law?
Well, in most of the international arbitration cases, the predominant law is international law, and the national law is somewhat secondary. And I usually make sure that I have people from that national legal system either on my team, or I retain those counsel to work as co-counsel with me. Now, in terms of concepts, I mean, I may be a common law lawyer, but I studied civil law, and I've done enough in terms of civil law. This is not rocket science. I know what the nuances are and the theories are. Of course, you need someone from that system, but in terms of understanding it, it's certainly not impossible.
Excellent. Would you recommend focusing on domestic litigation or a specific area of practice like M&A before turning to arbitration? Or you think that you can focus only in arbitration since you finish your education and then it's fine?
You know, it really, again, it depends. I think, you know, so many of the big arbitrations either are the result of a deal going bad, an infrastructure deal or a financing or something. You need to understand that business, that industry, and it would help to have some background in those areas. And I also find people that have studied economics certainly have a good approach in understanding the dynamics of a given investment or, you know, arbitral dispute. But, you know, it's very, I think, individual.
Yeah, and then maybe the economics sometimes are very important for damages, right? That is one of the key issues for us, for the people that practice international arbitration, that suddenly you have to discuss with your expert, your quantum expert, and it's completely different than what we do, you know, because you can understand civil law or common law, but then turning to finance or economics to understand the report, it's a bit difficult. So, yeah, do you think that, would you recommend to young practitioners to learn more about these technical issues, such as corporate law, corporate finance, or economics, in order to be better prepared on quantum issues, or you can learn it by practicing?
No, it's incredibly important to know and understand economics, damages, because believe me, the people sitting on that tribunal don't know it any better than you. And you've got to distill it down and make it reasonable and understandable and to them. And at the end of the day, that's what you're doing. So you've got to understand it. You have to know what's wrong with what you're saying and what's wrong with what your expert is telling you. You don't want to find that out during cross-examination.
Yeah, and you never thought that you will be doing this, like discussing about the economics or finance, but yeah, that was happening.
It's at the heart of it. It's at the heart of it.
Yes.
You know, the theories are very nice theories, but you've got to understand what it comes down to.
And in the end, it's what matters, no? Because quantum is the most important part.
Yes. Yeah.
So since we are getting out of time, and because Rémi then has another questions, another section, my final question will be: what does the road to becoming an arbitrator look like for young practitioners?
Well, you know, I always reflect on what I did and how I started, and it was doing very small cases at the AAA. And you do them and do them well, and people then want to use you to do bigger and bigger cases, and you begin to develop a reputation, and you can start doing some things well beyond that. But you also, I think, it's important if you serve as a tribunal secretary and you get to know the people at the various institutions, so that you have, you know the national committees of the ICC, you go to the seminars, you're familiar with the rules and the nuances and the people involved.
Perfect. Thank you very much. I will pass the floor now to Rémi to ask about tips in written and oral advocacy skills.
Absolutely. Hello, everybody. Thank you very much, Nicolas. Thank you, Carolyn, for being among us today. It's a real honor, indeed. We'll be indeed spending a few minutes talking about written and oral advocacy skills, and we have a few questions on this. But maybe for 1 second or two, let's step out of all these technicalities in order to know you, Carolyn Lamm, maybe a bit more as a person. And could you, stepping out of the box, could you maybe tell us what is your favorite book, for instance?
Oh, now that's a good question. That's a good question. I think, I spend a lot of my time reading briefs and cases. I can tell you about the most recent Fifth Circuit decision.
And you're not allowed to quote an arbitration book. This is out of the scope.
Well, I think that right now, I think some of the new books coming out on the current administration are very interesting.
Good. Okay, let's dive back into technicalities. So, and with tips on written and oral advocacy. And maybe my first question will be regarding your management skills. A question was asked as to how do you manage large arbitration, which include numerous, like hundreds or thousands of exhibits, to be effective when writing pleadings and guiding arbitral tribunals through these documents. You somehow touched upon this topic previously, but maybe you can be slightly more exhaustive on this specific question. Well,
no, that's a very good question, and it's exceedingly important. And the answer is you don't do it alone. You always have a structure, and we always, number one, the database, and the ability of the database is very important, so that, of course, you're using as much AI as you can in terms of organization, in terms of the flexibility of the database, being able to search and put together documents, etc. It used to take hours and hours, and now it doesn't. So you can really manipulate the data so much more to bring together the evidence of the various issues and concepts and witnesses, etc. So that's a big thing. You need someone who really knows that, and then that person has to manage usually 2 or 3 younger ones as well, or shall I say less experienced ones, who will work with the clients to get the documents. But obtaining the documents, it's not only from the clients, of course, that's step one, but from the opponents in the document production requests. And if there are any other mechanisms like the 1782 in the United States, and I know there are analogous provisions in many national laws where you can go to the national courts to get from third parties documents that for some reason, usually they're not very helpful, that the other side won't produce. So amassing the evidence is one big chunk. Usually I have a separate team on the development of the legal theory. And, we all know what's FET or what's XPro or whatever. You need people who are going to really drill down on the latest and greatest in various ways that others have approached it, and with the nuances of your case, what are going to be the very best arguments. So I usually have a smaller team of people who love to do the legal analysis and work with me on the strategy. Then I have a separate, usually, damages team. People who really drill down in terms of the harm or the lack thereof, and usually most important, causation. so many cases turn on causation in terms of there may be a big harm, you may have lost an airport, but what caused that? Was it this guy who's suing us, or was it something else? Was it yourself? So you really, on damages, it's beyond an accountant's function. And then, of course, developing the facts. I usually have yet some others, but people move back and forth from all of the areas depending on what, but you usually have someone working with you who will assist in getting the witnesses lined up, getting the interviews all done, etc. And finding witnesses. It's not easy.
Good. So the bottom line is that it's a common effort. It's a team effort. That's how we make it.
It's a big team effort.
Beautiful. Thank you. Very clear. Now, when it comes to your preparation, your personal preparation to an opening or a closing statement, how do you personally prepare for such statements? Do you, for instance, record yourself? Do you practice in front of a mirror? How do you prepare yourself?
That's interesting. And everyone has different methods. First of all, I read everything that we've said. I read at least outlines of what the other side has argued, and I put together what I want to say and what I think will be most compelling to the tribunal. And on many of these cases, you've got 2 hours to put on your case in an opening. You've got to distill down thousands of pages of briefs and evidence, etc. And it usually takes me a huge amount of time to sit in a room by myself, maybe with one other person, going over the submissions, the arguments, making with some other person the slides, and figuring out how is it best to present this? What's going to be the most effective way? I don't usually, unless it's incredibly intricate, but I don't usually write it out. I argue from slides, and I'll make a few notes on the side or something. And I have, of course, in the slides, the key evidence. And so that you're arguing from the evidence and arguing, from your notes, but by that time, you have such an understanding of the case and you so much want to convey that you don't need to write everything down. There are some instances where I've practiced arguments when I've made big circuit court arguments that are pure law. Now, I will say the argument I ultimately deliver when I stand up in a circuit court is quite different from all of my practices, but I've gone through every argument and know it cold, and I can respond to the facial expressions of the judges, to the questions of the judges, etc.
Beautiful. Okay, thank you. Now, maybe a question as to your appreciation as an arbitrator. When you sit as an arbitrator in this role, what techniques, what strategies have you observed that tend to be totally ineffective or unpersuasive when presenting oral arguments?
Well, I think the most important thing is that advocates have to have something that hangs together. Because you would be surprised how quickly on the other side of the bench you figure out that someone really doesn't know what they're talking about, or it's really a puff. So I think one of the big things that I've observed is sometimes people don't believe in what they're arguing. And you really can cut through that pretty quickly if you're sitting on a tribunal. You ask questions. On the other hand, one of the approaches that I follow when I sit on tribunals is I feel very strongly that everyone should have the opportunity to address the issues that are going to be the critical issues for the tribunal to decide. And so I don't care if it's going to help my party or be perceived as hurting my party. I will ask a question to give them an opportunity, if they haven't fully addressed the other side's arguments, to address it, because I know what's troubling the other members of the tribunal. I know they're getting hung up on something, and I feel like I want to get my guys, or the ones that appointed me, the best opportunity to be able to address it with their evidence and their arguments. I can't make it for them. And, but I can ask the question and let them do the best they can. And that's why arbitrators' questions are usually very important.
Absolutely. Let's keep this on, like, the bottom line of this. Yeah. Arbitrators' questions are usually very important. Yes. And maybe a last question. I see running out of time, but many attendees here are from civil law countries. A lot I see are from Latin America. We're not necessarily used to cross-examination in these legal systems. So maybe a question on cross-examination. What advice would you give to a young practitioner, a young arbitration practitioner, who wants to practice cross-examination? What are your top tips to conduct cross-examination?
Well, there really are different methodologies. I've certainly seen enough British barristers, with all the pomp and circumstance of shouting out, I put it to you. I must say, I don't always think it's the most effective thing, but they do. They do. I think what I have found the most effective is you have to know, anyone you're cross-examining, you've got to know that subject matter cold. You've got to know any exhibit you could catch them on. You've got to know any past statement. You've got to know all of the evidence related to that person. And then remember, your tribunal is listening to exactly what you're doing. It can't be long, convoluted, double questions. It's got to be short, concise, direct, clear, so that the tribunal is following along and they say, yeah, what about that? Why is this guy saying this? And you've got to listen carefully to your witness and control it and catch them. There are very few witnesses that you don't catch trying to say something that's a little bit off. And you can only do that if you've got a good document to come back on. And if you know it well, you can't be afraid of coming back to say, what do you do with this? What's this? If you don't have something to get them on, move on. Don't let them blab, because they will, and they will do you in.
Okay, thank you very much. I think this was very insightful to many of us. I think Orlando has one or two questions on a subsequent topic now.
Yeah, thank you so much, Carolyn. I think we are gaining so much from your answers. And moving out now to commercial investment arbitration, I would like to ask, what is your favorite investment arbitration case and decision?
Oh, that's hard, because I have many that I like. I don't know. I must say in the Abaclat case, on the jurisdictional issues, that's the 180,000 bondholders against Argentina. And that was my case with a great team. And in that case, I think it was one of the first where there were mass claims, and it was very significant in terms of size, etc. In that one, I think it is one of my favorites, and Ojamid called it the best case in a decade. Many of them have gotten similar accolades, and it was interesting because it was very different. And under the language of the BIT, we were able to establish that bonds were investments. We were able to establish that given the 16 different times in the BIT, you could in fact find multiple investors mentioned, including in the disputes clause. We did prevail on jurisdiction. We then settled the case before the merits decision. I to this day have not found out what it would have been, but it was settled.
And you know what? I feel very privileged because it happens that Avaclat is also my favorite case. So, I mean, it's such an honor being here discussing Avaclat with one of the persons who crafted that massive claim and all the challenges that you encounter by crafting that mass claim. And do you envision that we're going to see more mass claims in the future of investment arbitration?
Well, you could if BITs don't exclude them. And in fact, BITs do include multiple, investments and investors in a single proceeding. I don't know why you wouldn't see more mass claims. For a mass claim, you really do need many who are similarly situated. So you need some governmental act that had a very significant ripple effect, but many of them are that way, so that all of the claimants were injured in a similar way.
Yeah, and thank you so much. And well, you know that UNCITRAL Working Group 3 has substantially devoted a lot of time to criticize investment arbitration and to try to improve the system. And even the EU has or is promoting an investment court that will put an end to the arbitration era. So do you believe that investment arbitration is rightfully criticized? Do you think that investment arbitration will end soon? What are your views on this criticism and the UNCITRAL Working Group 3?
I always take criticism and analyze it carefully. Do I think that the investment courts are a better way? Absolutely not. Why would a court, all appointed by states, in fact, be any more reliable or legitimate than a system where both the states and the investors get to appoint? Does it mean that there shouldn't be some tinkering with some of the approaches and some of the rules? Well, yes, maybe there should. I don't think the investment court is the answer. I also don't think, you have to analyze it from a number of perspectives. And of course, one is from the perspective of a major investor. And a major investor going into a developing state, a capital importing state, they're not going to agree to go to national courts. That's not the way they're going to solve any disputes. Are they going to agree to go to an investment court all appointed by a state? I don't think so. So I think even if you see a change in some treaties, I don't think you will see a change in 3,000 treaties, even 2,000 treaties. You will still see in the investment agreements going into a country a dispute resolution system that has a balanced way of resolving the dispute. And for those, you also have to step back from it and think about the capital importing states are all competing for dollars or whatever, rubles or rupiahs or whatever they're competing for. They're competing for imported cash to build their economies, to build their infrastructure. And if they think that, in fact, offering a better dispute resolution system will attract more investors, well, why are they going to go to some court that's not going to make them happy? They'll say, oh, well, the guys, Kazakhstan did it, Uzbekistan doesn't have to. And that's just a,
For sure. I
Yeah.
agree with your point. I mean, it's a potential solution. Well, it's something that we will see if investors and states are willing to accept in order to keep promoting an efficient mechanism for dispute resolution. And moving a little bit on enforcement, I would like to know if you have advised on the enforcement of an annual arbitral award in another jurisdiction different from the seat where the award was set aside. Can you share any experience on this?
Only the jurisdiction where at the seat would have the power, the primary jurisdiction, to annul an award. So if another jurisdiction annulled it, I don't think many under the New York Convention would respect that annulment. People try these things, but most courts under the New York Convention reject those things. The cases that I think you're probably familiar with, like Chromalloy v. Egypt, that case was the court at the seat annulling the award, and the U.S. court decided not to respect it because they weren't respectful of Egyptian courts. That doesn't mean if India decided to annul the same award, that any other court in the universe would respect that, because that's not what the New York Convention requires. Now there is France, and France has a little bit of a different view under the French law, but I'll leave it to the French lawyers.
Well, and with that, I think I'm running out of time, and I would like to know if our friends can help us to move on the conversation to find some questions from our audience. Nicolas, Rémi.
Thank you, Orlando. So we are running out of time, so there is space only for a few questions. I chose from the chat and the Q&A chat. The first one will be Mijael Cienfuegos. He is asking which option could be better, LLM specialized in international arbitration or LLM general with different international arbitration courses in the curriculum? And what are your views? In especially LLM or someone more general, broader?
No, I understand that. And, I guess I would look at where they were and who's teaching. If you've got one slate of all, great teachers that you would want to learn from, that may be the best one to choose. If the other one gives you some good teachers and some other interesting subjects, that's up to you.
Exactly, perfect. Thank you very much. Then Maria Ramos is asking, what do you look for when hiring a foreign lawyer, especially one from Latin America?
Well, and that really varies depending on the office we're hiring for. Because obviously we have an office in Sao Paulo, an office in Mexico, we have offices all around. In the US, typically you would want a JD plus, either an LLM or something. And language ability is very important. If you're speaking Spanish and English and you speak both well and you can write in both well, that's very interesting because we have so many cases that are argued in Spanish and English. And it all depends on the tribunal, which one will be predominant. Some are in Portuguese, and we have one group that will work primarily in Portuguese. We have some in French, some in Russian. We have all different languages for the various arbitrations, and we put together teams that both have, the language ability as well as the international credentials.
Excellent. And the last question that I guess it's going to be short. After all your experience, do you still prefer arbitration?
Yes.
Someone was asked by Costanza Sorsoli, and I assume that the answer will be short. Excellent. Thank you very much. We don't have more time for questions, so I will pass the floor to Rémi again to do the closing remarks. I thank you again very much for all your patience and everything. I think it was really, really nice, and thank you very much.
Well, thank you. It was great to work with all of you.
Thank you all. Thank you, Nicolas. So very, very short closing remarks to be on time. Just to introduce maybe briefly LAIAC, so the Latin American International Arbitration course. So a 3 weeks course on international commercial and investment arbitration, co-organized by the University of Buenos Aires and the CIDS, the Geneva Center for International Dispute Settlements. So originally LAIAC was meant to be held in presential, but of course these past months, due to the present sanitary situation, we have had to adapt, and so we have gone online like everybody else. And this is why LAIAC is now so online for this year's edition and is being held right now, actually, for the next 3 weeks. So I'm sure many people from LAIAC are actually attending today's webinar, but for those who are not familiar with LAIAC and would be keen to joining us next year in Buenos Aires, maybe just a very few words to introduce you to the program. So as previously stated, it's a 3 weeks program, which aims to enable participants to acquire a general understanding of both procedural and substantive matters in commercial and investment arbitration. So for instance, this year, the general course is delivered by Gabriel Kaufman-Köhler, followed by a number of thematic courses such as investment versus contract dispute by Zachary Douglas, or jurisdiction and admissibility by Marcelo Cohen, enforcement of awards by Jonathan Blackman, annulments of awards by Eduardo Zuleta, energy disputes by Eduardo Silva Romero, and construction arbitration by Claire Connelan and Silvia Martilli from White & Case. So I will stop here, although there are many more features to the program we could expand on. But for those of you wishing to enroll in LAIAC for next year's edition, feel free to visit our website, and admissions will open in December for next year's edition. On this note, thank you very much to you, Carolyn Lamm, for today's interview, which was, I'm sure, very beneficial to all attendees. And thank you to Orlando and to the whole Young ICCA team for setting up this webinar today. So thank you all. And again, thank you, Carolyn.
Thank you so much. Thank you.
Thank you so much. Have a great day. Bye-bye.
Bye-bye.